And I'm saying, so an overview of what we're doing today in this presentation on due process hearings is first, we're going to do general considerations. What is a due process hearing? And all those questions. Who does it, when, why, and so forth. Then we're going to do a very quick overview of alternatives to due process hearings. We thought that was helpful because due process is not the only tool. There are three very good tools, and they all kind of work well in different situations. So we're all going to share kind of our own perspectives on what might be helpful when and what to think about if you're thinking about due process. After that, we're going to get into the real nuts and bolts of a due process hearing. How do you start one? What happens next? What happens at a hearing? What happens after a hearing? And then we will finally talk about, do I need an attorney? If I'm a parent or a student and I want to pursue a due process hearing, do I need an attorney? So we'll talk a little bit about that. I'm sharing this agenda with you partly because if we're going to kind of save questions till the end, but I encourage you to post them while the presentation is going on. It may be that if it's relevant to something we're talking about right then and we know we're not going to address it later, we might answer it during the presentation. But if not, we'll be answering it at the time at the end with as much time as we have available to us. And I'm going to say again, if getting flooded with all the questions at the end may mean that we can't get to your question. So if a question comes up, please put it in the Q&A and we will be monitoring that and getting to it at some point during this presentation, we hope. So with that, I think that we can get started and I will hand it over to Tara to talk about some general considerations.
Okay.
And you can flip, there we go.
Forward to the next, we're already there. All right, well, thank you all for being here, and I hope that we can provide you a lot of information. Basically, the question is, what's a due process hearing? It's an administrative process, which just basically means there's some formality to it to try to reach a resolution between a dispute that may arise from a parent and a district regarding how we provide supports and services or eligibility determinations related to a student with a disability. The due process hearing can be started by either party. I would say more often than not, it is going to be initiated by a parent, but it could be initiated by school districts under certain circumstances, and we'll touch upon some of those as we go through. What it starts with a written notice, basically a complaint that the parent identifies what it is that the district did or did not do that they disagree with respect to their child. Typically, it relates to identification, evaluation, program and service recommendation, or the failure to recommend a program and service. And then that written complaint is what is processed and then becomes the basis of the formal action that will then be appointed and go before a hearing officer who's going to basically sit as the judge and review the issues and concerns. Both sides get to present information and evidence, but the costs that are associated with that hearing are the district will pay for a stenographer or for a live transcript, meaning all of the information that's presented has to be documented and recorded. That is typically in the format of a written transcript. The district pays for that. The district also pays for the hearing officer to come and preside over the hearing. So those are costs that are borne by the district and not by the parent. If the district has its own counsel, obviously the district will pay for that. Parents may be represented. They are not required to be, but if they are represented, unless the parents are successful at the hearing, the cost of their counsel would be their own. And we are going to talk about attorney fees towards the end of the presentation. But I will say that there is a very helpful guide that the State Education Department came up with, a number of questions related to impartial hearings and a lot of, I think, what are very common questions. And we included the hyperlink in the presentation materials. I believe that everyone will get a copy of the presentation following when they also send out the link to the YouTube video if you wanted to review this again or if you missed info. So just keep that in mind. But we try to both provide you the practical as well as good resources that will help you. If you want to go to the next slide. So one of the common questions are what types of issues can be addressed? And as I sort of hinted at, it really has to do with pretty much anything that can come up in the context of special education. So that may be things such as child find, which is a fancy way of saying, did we identify and evaluate a student with a disability to determine whether or not they require supports and services? The nature of the evaluations, was it sufficient? Did it appropriately identify the areas of need for the student? If a student is found eligible, sometimes the issues arise related to placement. Is this too restrictive? Is this not restrictive enough? Does the student have opportunities for integration? We are always going to be looking at, program and service recommendations in the context of the least restrictive environment, which means students should only be removed, students with disabilities should only be removed to the extent necessary to access key programs and services, but otherwise they should be integrated and participating to the greatest extent appropriate with their non-disabled peers. Sometimes the nature of a program recommendation may be at an off-site location or a special program where they may not have as many options available for integration, but even then it should always still look to the least restrictive environment appropriate to meet the needs of the student. FAPE is making sure that whatever programs and services that are provided are meaningful and help the student develop the skills that they need to make appropriate progress. It's going to be appropriate in light of the student's circumstances, but that is always going to be an individual assessment. There's no FAPE standard that doesn't take into consideration who this student is, what their needs are, and what the program and service recommendations are. Declassification, which should be, in my mind, a victory, because if all has gone well, the student has learned the skills that they need, they have remediated deficient skills, they have learned how to use compensatory strategies and accommodations, can be a wonderful experience, because that means that they are now at a point where they can fully participate in gen ed without those supports. But in some cases, there are concerns about whether it might be being proposed too early or whether or not the student does not yet have independence on some of those skills. So that may be an area of disagreement. Pendency is a legal term of art, and it basically means when a hearing is requested, the program that is being implemented at the time of the due process complaint is typically going to be where the student will stay during the course of the hearing. So for example, if it's a hearing requested related to a disagreement with discipline, while the hearing is proceeding, in most cases, the student will remain in that current program and service pending the outcome of that hearing. Speaking of that, we also talk about disciplinary placement and manifestation determination. Those are issues along with pendency that oftentimes will result in an expedited either hearing or a time-sensitive ruling to make sure that we have an agreement and a place and programs and services for the student while a hearing is going forward. Can you go to the next slide, Laura? So throughout the course of hearings, one of the questions is what relief can I request, or what relief may a hearing officer order? So as we just talked about pendency, making sure that during the course of the hearing, the student is not being deprived of whatever appropriate supports and services that were already in effect. So if there's a disagreement over declassification, pendency will maintain that the student will continue to receive those services during the course of the hearing. Classification is, sometimes an issue. I will always say that, to me, this is just my opinion, classification is only relevant in a few areas, because for me, classification category is more what we report to the state. I'm more interested in the content of the IEP, how the student is described, because that's really what should drive the IEP. But sometimes classification can be a particular concern because of trying to access a particular type of program. Those special programs or schools may only accept, based on state authorization, certain classification categories. So it could be an issue. More typically, we see a lot of issues over the nature and extent of evaluation. And remember, one of the points of relief that can be requested is if the parent disagrees with the district evaluation, there's always the possibility of requesting the relief either through a request to the district or through due process or another means to request an independent evaluation that would be funded by the district, but it's someone who does not work for the district who will evaluate the student and produce a document and an evaluation, which the committee must then consider in determining appropriate supports and services. Sometimes either because there's a new evaluation or there is an issue that a hearing officer has heard and determined needs to be addressed, they may remand or order the CSE to reconvene. Oftentimes, if an IEE has been completed, there will then need to be a CSE meeting to determine what do we do with the new information, and does that alter or change the program or service recommendation for a student. The program and service recommendation are common issues as to frequency, the nature, the type of service, and sometimes getting into, more specific issues such as the level of support, the number of providers, or the manner in which it's delivered. We do have compensatory education services, which kind of is a little bit of a confusing concept because we talk about compensatory services. Legally, it's supposed to be services provided to a student after the student is no longer eligible in order to allow them to receive a FAPE, even though they may not have received it during the time that they were eligible for services. That's one of the legal definitions. However, we use it kind of as a general term for whenever we've determined a student did not receive appropriate services, to address that by providing either makeup services or other supports that are designed to remediate the deficit caused by a failure to implement FATE or some other deprivation. In cases where there is a student who is unilaterally placed in a non-public school or another public school at parent expense, there is the possibility that a hearing officer can order tuition reimbursement. That is one of those cases where the parent will bear the burden to establish that their program is appropriate, and that is predicated on the presumption that the district did not establish that it offered the student a FATE. And then last but certainly not least, there's what I call the other relief, which can be things such as reimbursement for out-of-pocket expenses. That could be transportation if the parent arranged therapies while there was a dispute over whether or not the student qualified for a particular therapy or support. Those are the different types of remedies that can be ordered. Next slide. So we did want to stress the importance that due process is one means of resolution, but it is by no means the only option for resolution. Can we go to the next slide? Because I do want to touch base on mediation, and I also noted that Sherry Greenleaf, who runs the mediation program for the state, happens to be part of this. And mediation is another means to try to come together and reach a resolution. It's not a CSE meeting, but where there is a trained mediator who understands and has been trained on specific special education issues and concerns, and they try to facilitate a mutually agreeable resolution between the parent and the district. Sometimes they will, do individual work with both sides. Sometimes they'll do a group work, but there are certain benefits to be, considered when you look at mediation. Even though the district pays the lion's share of expenses that relate to due process hearings, one, they're time consuming. Two, it can feel unnecessarily adversarial. Three, if the parent is represented by counsel, there are attorney's fees there. The district has typically attorney's fees on its side. And, sometimes even, you may come to an outcome and there's a decision issued. It may not resolve all of the issues and concerns, and so there may still be tension. Mediation offers sort of a neutral in-between option where sometimes you can come together and look at where do we agree, what are our particular issues, and maybe without all of the form and substance of the formality of a CSE meeting, try to come to a mutually agreeable conclusion. It's not a mandate. Neither party can be strong-armed into a mediation agreement, and both parties have the ability to say, okay, this is or is not working for me. But if you come to an agreement that both parties have presented and agreed to, oftentimes we find that these can be some of the more successful outcomes. The other important part is it's free. The state pays for that mediation, so it doesn't cost the parent or the district anything. And it is also another means that is confidential. If you are not successful, it does not prevent you from having the ability to still pursue mediation or other options. And there is a special education mediation website on the State Education Department webpage. That hyperlink is included at the bottom. And I would encourage you, as you're looking at the options, and we'll touch upon this towards the end, look at all of your options and decide what works best for you. and the circumstances or the issues that you're presented. Mediation is great if it's a single or a small issue and it's really just you want to try to sit down and hammer it out. Sometimes it can also get you a resolution much faster. So then next slide. Another alternative to due process is the state complaint process. If you are not aware, if a parent disagrees with an action or feels that there was a violation with respect to the implementation of their child's IEP, they can file a written complaint with the state. I will stress that it needs to be written because in addition to submitting it, you need to have an original copy and a signature in addition to having the specific information contained within the complaint. A complaint must be related to an allegation of some violation or failing that happened within 1 year of the date that you filed the complaint. So it's important to make sure that if you are looking at a state complaint, the issue you're complaining about will still be within the relevant time frame. If it happened 2 or 3 years ago, a state complaint is probably not going to be the vehicle you choose. But if it's something that happened, and in most of these cases, if there's a frustration, it will usually come up relatively quickly. The state complaint process is an available option. The parent or the complaining party would submit in information, and then the state is going to review. And if they accept the complaint, meaning it falls within the scope of what they have the authority to review. And again, that can be things such as evaluation, identification. Did the district follow the process? Did they issue proper notices? Did they afford the parent the opportunities to participate? The list of things that they can review is long. If they determine that the answer is yes, then the state is going to send to the district a complaint saying, we have taken these issues for investigation. And then they will typically request data and documentation from the district and encourage a written response from the district to basically address the concerns that are under investigation. The state then has its period of time, which is 60 days, to make a determination as to the allegations. And they'll either sustain, meaning they found that the violation did occur. And in those cases, they will typically direct corrective action if it's warranted, meaning the district needs to hold a meeting, issue proper notices, go back and reconvene the CSE and discuss compensatory services. If they find that the issue was not sustained, meaning that they believe that the district did comply, then there will be no corrective action taken. There isn't a per se appeal from an outcome of a state complaint, but if you believe that there is a material inaccuracy to an outcome or finding, you still have the opportunity to submit a note of disagreement, and the state will consider it within, I think it's a 15-day time frame. I've only had it happen once that we, disputed, but that is another option. And again, the state can offer and recommend and direct remedies from the district as part of its requirement, and sometimes it will be to go back and review, whether or not compensatory services are required if, for example, the student did not receive services during a period of time where there may have been an absence of a provider or there were some other issue that was not addressed, in addition to other relief that may be deemed appropriate. There is a Q&A, as always, on the State Education Department website, which I would encourage you to take a look at. And I hope that that will be helpful. And at this point, I believe I'm turning it back over to the lovely Miss Keegan, who will pick up from here.
Thanks, Tara. That was a very effective overview of a lot of information in a short period of time. I meant to clarify something in the beginning of this presentation, so I'm going to clarify it now because we got a question about it too, which is there a difference between upstate and downstate, or the city versus the rest of the state when it comes to these things? And technically, no, there shouldn't be any difference because it's all governed by federal and state law. But in reality, the way due process hearings are operated in the city versus outside the city are pretty different. The timelines and other things stay in place. So most of the information we're providing today is going to apply, but things just happen a little bit different in the city. So I will say, for those of you who are coming from the city and are looking at information on city due process hearings, there may be some differences because what we're focused on is mostly upstate or the rest of the state. So apologies for that, but if we tried to do both, we would be here for much longer than we have today. So as I mentioned, we thought we would all kind of share our perspective on due process hearings versus should I do mediation? Should I file a state complaint? Should I pursue due process? And there's a lot, like, this really needs to be thought out carefully, because jumping into due process is not always a good idea. And I have seen a lot of people become frustrated with the process, or maybe not get the remedy that they were seeking or needing because they only went that route and didn't think about other routes. So typically when I'm talking to parents or students who are finding themselves at a crossroads with the district, I'm going to ask them what the nature of the issue is. And if it's a procedural issue, or if it's a delivery of services issue, I think it always makes sense to do a state complaint. You don't need an attorney to do a state complaint, and you're getting a pretty quick turnaround, with a 60-day requirement to investigate and make findings. Um, it's it's free, and besides that, you don't have to actually know what part of the regulations or the statutes the school district may be violating. You can just say, here's what's happened, and the state has to actually think about, okay, if all those facts were true, which regulations or statutes would that imply? So the state is kind of doing some of the work for you. So that's why you kind of don't need to be an attorney. It's definitely a parent-friendly process. So if there's issues with my kid is on home instruction because there's no placement available, or I'm on wait lists and they're not getting their tutoring or something like that, that's a great thing to use a state complaint for. You don't need due process for that. The state will come in, assess, and will likely be telling the district that they need to make sure that they're providing a FAPE that's a free appropriate public education for the student, or providing compensatory services. If the right people aren't at the meetings, like you really wanted someone there, or you feel like there was just the CSE chair and there wasn't other people that are part of the CSE, that's kind of a procedural thing. Or if the implementation of services or an evaluation hasn't been done within the prescribed timelines. So things that are procedural work pretty well for state complaints. What doesn't work well for state complaints is something like, my student should be in this placement, or my student should be getting these services, because those are kind of individual assessments that are really required to be made by the Committee on Special Education. So the state is not sitting at that table. They're not reviewing all of your child's evaluations. They are looking at, is there compliance with these things? So if the issue comes down to, I believe my child should be getting this, it's not on their IEP, or they're refusing to put it on their IEP, then I think your better options are mediation or due process. Mediation, I think, is really underused. I know that the most recent statistics show that there's a really good success rate when you use mediation. I remember when I started in this field, someone told me that a CSE meeting is like marriage with no hope of divorce, because you are married to the school district and the CSE, and that's really, you are there as long as the student is there. And so there are years and years ahead of trying to get along and plan for the student. So keeping communication open and respectful is really important. And that's a two-way street, and it can go awry in a lot of different ways in many ways. So I'm not faulting or placing blame, but if there is the chance of communication, then mediation is a really great first step to see if we can get some resolution to this. And sometimes just having a third party, a neutral party, who's there with some special education training, can can help level the playing field a little bit in that exploring different options that a parent may or may not be aware of, or getting right to the nitty-gritty of what is it that's getting in the way. So I think, and the other thing is, you kind of have nothing to lose. I mean, if it's an immediate issue, then you might not want to do mediation, but mediation usually doesn't take that long to get scheduled. And again, you're not losing anything, and you may actually find yourself being able to better communicate with the district. So all of that being said, sometimes that's not going to work. And we may be fighting over a placement, or we may be fighting over services, or something along those lines, and due process then may make sense. I just think parents need to know what they're getting into. And I'm going to talk about this a little bit later. I think there are very few parents who have the time, understanding, the time and understanding of the legal aspects of special education to go it alone in a due process hearing. I'm not saying that parents can't do that, but I think it's a major undertaking. And when Jean starts talking about the requirements for due process, you will see that there are things there that if you miss them, they're just procedural things, but if you miss them, or don't do them, you could lose. So that's problematic. You also have a third party making this decision. It's not within the confines of the CSE. There's a third party who you don't know who's going to be making this decision. So, those are things to think about. On the other hand, there are some situations where you have to file a due process complaint to get the attention of the district, or to let the district know that this is a really serious issue and you're willing to go to bat. And indeed, there may be many occasions where you should be going to bat. It just shouldn't be entered lightly. One of the advantages that we'll talk about a little bit later is that there's an opportunity for a resolution. So if you file for a due process, the district knows then that they have to appoint a hearing officer, that they are going to be paying for the costs of a due process hearing. They pay for the hearing officer, they pay for the space, they pay for any staff that have to come as witnesses, they pay for staff that have to sit there through the hearing. So there's like a financial cost to the district as well, which may come into their thinking when they're thinking about maybe it's easier to just resolve this and find a compromise. So it is a way to kind of bring it to the next level of seriousness and try to work through a resolution, but also knowing that you may have to go through it. So those are some things to keep in mind from my perspective on those three choices when there's a conflict. I will turn it over to Tara.
I agree with Julie in terms of if you have procedural issues, I absolutely agree a state complaint may be a meaningful resolution, because if it's a matter of you have an IEP that says X, but the student is not receiving that, that's a simple, straightforward thing. I would hope in most cases that the district will have already touched base with the parent to try to discuss proactively if there needs to be any makeup of missed services. But if they're not addressing that issue, that is one straightforward reason why the state ed complaint process can be particularly helpful. Mediation is great where you're close, but perhaps just need a little bit of assistance to kind of get through the finish line, because maybe you are on the same page, but you just can't quite work through details. That I think can be particularly helpful. And due process, I would say there are some instances where it is necessary because it requires an immediate relief on certain issues, such as we need to address the issue of pendency. Or in cases where it is a district-initiated complaint, it may be that the district is seeking a student's removal, if there is a dangerous student, that they feel that continuing the student in that placement would be likely to result in injury to that student or others. Those are where there are both time-sensitive components, and then there's also the larger issue. When the dispute has come to a point where there has been probably multiple CSE meetings and you are just not coming to any form of agreement, that may be where a due process complaint may be the means through which you will exercise to try to come to an outcome that will resolve this issue. It may not be the outcome you like. It may not be all of the relief you're seeking, but it will be a definitive determination, and you will come out of a hearing with an order that will direct the actions of, the district if they need to do anything corrective wise. It may, substantiate a determination or a concern you've raised, or on the flip side, it could be that a hearing officer might find that the district did do what it was legally required to do. But at the end of the day, that decision is based on the law and it is based on the facts, and that will be a final decision. You have appeal options, but it at least gives you what you think of as in terms of a hearing where both sides get to present their information to a third party who is knowledgeable about the law, and then they will render a determination taking all of that into consideration. Mediation is knowledgeable person, but at the end of the day, they're still trying to help you and the opposing side work your way through it. And complaints with the state is going to come in and say, this is what our requirements are, and this is what needs to happen, and this is what did or did not happen. So that's sort of my 2 cents worth, all of which are valid. I think I agree with Julie. It depends on the case and it depends on the issues that are being presented. I will echo the concern that due process can be very difficult for parents, particularly if they're pursuing pro se, because there are a lot of requirements. Not to say that there are not, hearing officers may not offer guidance and direction, but just be mindful that that can be a challenge. Okay, Jean.
Thanks, Julie. And I will echo the same concerns and I guess kudos for due process hearings. But I really want to say that one thing that a due process hearing really has over the others is that it has an ability to solve multi-year, multi-issue cases for families, and to really finally put the student in a better place after years of maybe not being served properly. And that can include years-long failure of the district to satisfy the requirements of what they call child find. So to identify a child who, because of how they were presenting or not making progress, the school should have seen that they might be someone who would qualify for special education, and if they failed to do that. So due process hearings can handle those pretty complicated cases. Again, they can be for multi-years and multi-issues. And so that due process with that neutral third party coming in who does have training in special education and comes from a place of knowing they're certainly not administrators of the school district. They don't, but they may not have education degrees, but they are experienced attorneys. And they also, as I said, there's much training that goes into becoming an IHO. And the more time you spend as an IHO, the more you get to know. But we do have 12 hours of annual training per year. So we know the issues when they come up and the new advances, the new cases that come out. So that's a big advantage to the due process, to bringing a due process complaint. And I want to say that you don't necessarily need an attorney for every due process hearing. There are less complex cases that a parent can handle by himself or herself. For example, a case where they disagree with the evaluations that the district has performed. They could certainly take that to a state complaint, but it can actually file an impartial hearing for a complaint to get independent edivals, because if the district doesn't give the eval when you ask, there's really little else that can be done. The district would have to file a complaint to prove that their evaluation was appropriate, or pay for the evaluation that the parent is requesting. And that can be done by the parent. It's fairly uncomplicated. Also, the resolution process that we've mentioned already is a requirement. When anyone files a due process complaint, they must go through this resolution meeting. And that's a chance, it's not a CSE meeting. It's a chance for the district and the parent to get together to bring the decision makers to the table. There are no attorneys unless, usually there's no attorneys. If the parent wants to bring an attorney, that parent can bring an attorney to the resolution, but then the district will bring an attorney also. So, but it's designed where there are no attorneys. And you can actually come to an agreement, and that could be the end of your entire due process matter, because you can resolve it. And for example, if you're looking for additional services, you can resolve that through the hearing. It's a written agreement. You can change your mind within 3 days. So that filing of that due process complaint spurs that resolution meeting, which really does resolve a lot of cases. So that is important. I would say the cons of filing a due process hearing are what both Julie and Tara have said, that it's all about the relationship between the family and the school. And it is the due process hearing tends to become adversarial. There may already be a poor relationship between the family and the school for whatever reason. But if you have other children going through the district, protecting the relationship on behalf of your other children so that you can continue for them to have a good experience at the school district, that's where having a hearing, a due process hearing can make it really a challenge to preserving your relationship or making it better. And we've mentioned before, if it's a complex case, it's really hard to represent yourself in these hearings. And I will go into more detail in that when we talk about the nuts and bolts of these hearings. The other good thing about, and Tara mentioned this, but the other good thing about the hearing process is that if you don't like the decision, you can appeal it. And we'll tell you there's special timelines and things you have to do to appeal a decision that you don't like, but you can appeal it. So when you go to the first tier of the process, which is the hearing before the hearing officer, you have another bite at the apple if you don't like what happens. So I would say that it can be very complicated, but it is possible in more simple cases for parents to represent themselves. And I have had several parents over the years who did a very able job of that when we had a single year and just a couple of issues. So it is very possible, and one can do it. But we'll talk more later in the presentation about when you really probably should seriously consider having an attorney instead of trying to do the case by yourself.
Thanks, Jean. We're going to move on to nuts and bolts now, and we're running a little behind time, but I can't believe I did this. But one of the things when you're thinking about whether you want to do due process is I forgot to talk about pendency, and someone asked a question about pendency, but I mean, that's typically one of the main reasons that you might want to file a due process complaint. And what that means is pendency is kind of freezes things where they are. So I'm just going to use a basic example. Let's say your child is in a co-taught classroom and the proposal for next year is a self-contained classroom in a different setting, okay? And you don't want your child moved. You don't think your child should be moved. You think if there were other supports and services for your child or a good behavior plan, your child wouldn't have to be moved. If you file for a due process complaint, that invokes pendency. And what that means is the district and the parents agree that the last agreed upon IEP stays in place until the matter is resolved through the due process hearing. So if I filed a complaint, there's this new IEP coming saying my child's going to be elsewhere, and I file a due process complaint, my child is staying in their current setting until, or the equivalent of their current setting. So nothing more restrictive. So they would be staying there until we get through the due process and a hearing officer makes a decision that yes, it's appropriate that the child be more restrictive, or no, the child should be in a less restrictive setting, as you're hoping that they will find. Or you and the district may come to a resolution before, without having to go through the whole hearing. But that is the only process. Sorry about my voice. But mediation and state complaints, they don't freeze things in time. So if you need to freeze things where they are, then due process can be an effective way of doing it and give you some leeway to try to resolve this issue with the district while keeping your child in the same situation. All right. With that, we're going to move on to due process, the nuts and bolts of due process, and Jean is going to talk about that. I see that there's some questions about the difference between mediation and resolution, and we are going to talk about resolution, so we'll address those questions then. But thank you, everybody. We've got a very healthy number of questions here in the chat. I might try to answer some of them as we move along here. All you, Jean.
Okay, thank you. So when you do decide to file a due process complaint, that's going to be in the form of a written notice, and it has to include the student's name, the parent's name, their address, a description of the date of birth of the child also has to be included, a description of the problem. In other words, why are you coming to us with this request for a hearing? Including the related facts of the problem. And very important, that includes a proposed resolution of the problem. So for example, if you think your child is eligible for speech, you've had various CSE meetings, you still can't get them to have speech, you might propose a resolution of the problem to give my child speech. I've seen pro se complaints that were just that simple. And, you know, and we can talk more about that later, but just a proposed problem. If you're looking for a tuition reimbursement for what school year you're looking for. Be very thorough when you're describing your complaint and the reasons that brought you to the hearing. Because if you don't raise the issues in your complaint notice, you won't get to argue for them during the hearing, unless the parties agree. And I wouldn't even rely on that. Just you have to raise everything that you can think of. There is a statute of limitations for filing. So you must file your request for a due process hearing within 2 years of the date that the parent or the school knew or should have known about the alleged action that formed the basis of the complaint. And deciding whether the parent knew or should have known about the alleged action at a certain time, that is up to the hearing officer, and we base it on facts that are presented. So, and I say this because every once in a while, 2 years is longer than 2 years, but we can talk about that later. I don't want to get into the weeds right now. You file that complaint, and that complaint is deemed to be sufficient. We can move ahead with the complaint unless the respondent, and mostly it's the district because most due process hearings are brought by the parents. They have to reach out to the hearing officer within 15 days of the filing of the parent's complaint to say that they don't think the complaint is sufficient. It didn't have one of the key items. Let's say it doesn't have the child's name, birth date, doesn't have the parent's information. It doesn't tell the district why you want to come there. It doesn't tell the district what school year you're bringing the claim for. They will let the hearing officer know that, and then the hearing officer will need to quickly decide whether that complaint is indeed sufficient and it meets the requirements of filing. And the parent would have an opportunity in those cases, if they ask for it, to explain further why they think their complaint is okay. Let me see. There is also something that's very helpful, and that is a sample complaint form. There's a hyperlink to that in the slide. It is that form, I have seen it used many times. So if you thoroughly fill out that form and there's spaces for you to write a narrative, and you can include additional sheets of narrative if you want to, that should allow you to cover all the bases that you need to in filing your complaint. Um, the complaint must be mailed to the other party. You should, if you have a question about whether maybe you prefer to walk in the complaint, just call the district clerk. Your school should know about whether they can walk a complaint into the district and to whom they should send that. It's usually the special education department, but even if you give it to the district clerk will certainly get it to where it needs to go. So just you could make a phone call if you have any question of where to mail it, or where to whom to address it. Next slide, please, Laura. So when a complaint is filed by the parent, the district has to appoint a hearing officer. I believe it's within 48 hours. So that happens right away. The parent is entitled to prior written notice about the issues complained of. And the district, let's see, I'm skipping some of these. Let's see. So the district usually will file what they call a response to the due process complaint. And in there, they will say why everything they did they feel was appropriate, and that they disagree with the parents' probably allegation that the school failed to provide a free and appropriate public education. In the case where the district files the complaint, the parent has to send a response within 10 days of receiving the complaint that addresses the issues raised in the complaint. So can we have the next slide? The resolution session. So we talked about this before, and so the resolution session is required, and the district has to convene a meeting with the parents within 15 days of the notice of the complaint. Now, by agreement, you can extend that time period. And the exception to holding a resolution session is if both parties agree in writing to waive the resolution session. I don't see this very often, but sometimes there's already, it may be the relationship has already broken down, and they have had so many CSE meetings that they know that they cannot resolve the complaint outside of a due process hearing. So that's where you might see both parties waiving a resolution meeting, but it doesn't happen very often. If the parent doesn't attend the resolution meeting, we will just delay the amount of time it will take to get to the hearing to be held, because the district is entitled to have that meeting with the parent for the chance to resolve the issues that the parents are complaining about. And as I mentioned before, there's no need for an attorney there, but the parent can certainly bring an attorney if the district is bringing an attorney. But again, nobody wants to get attorneys involved at this stage. I think it does happen. I don't see that it has the best results. Okay, can we have
Jean,
the,
can I just jump? Do you mind if I just jump in here?
yeah, sure.
Just because I think Tara and I were going to talk about resolutions, but we really don't have time, so we're going to skip that. But there are a couple questions about what is a resolution session versus mediation. So I just want to
Sure.
just stress to everybody that the resolution is part of due process. So you don't have a resolution session, a resolution meeting, unless you've filed a due process complaint. So once you file that complaint, then the people that Jean just talked about get together in a room and they try to work things out and come out with a settlement agreement. Mediation is a whole different other option, and it's not mutually exclusive. You can try mediation. If it isn't successful, then you can move to due process if you choose to. But that is a process with a trained mediator who is helping facilitate a resolution or an agreement between the parties. In a resolution session, it is just the parents usually, and maybe the CSE chair or someone else from the district sitting in a room trying to hammer things out. I will say, Jean, I have attended as an attorney resolution sessions very successfully. So I think if you can avoid, I mean, I don't know if you have to avoid having attorneys there if you're represented, because I think the attorneys sometimes can work things out in that setting, but it really depends on a whole host of things. So you don't have to have an attorney there, but I will just leave it at that.
And that's a
But those
good
are
point.
the distinctions. Yeah.
Yeah, that's a very good point. So next slide, the hearing procedure slide, please. So in the hearing, there's a thing called a pre-hearing conference. And a lot of times when we have two attorneys, there's an attorney on both sides, and let's just say they are both quite sure that they're going to be settling the case because they've already been talking about it. I ask them if they want a pre-hearing conference and they say no, and we don't have one. And I'm fine with that because the attorneys know how best to represent their own clients in these matters. But for a pro se parent, I always hold a pre-hearing conference on the record. And what that means is I have the district supply a court stenographer, and the hearing officer and the parent and the counsel for the attorney have a pre-hearing where we go over all the nitty-gritty details of what's going to be um, the requirements for the hearing. We talk about evidence. We talk about any subpoenas. We talk about marking the evidence. We'll get to that later. But the pre-hearing conference, my procedural advice to anyone out there who's thinking of representing themselves at one of these hearings is if the hearing officer doesn't ask you about a pre-hearing conference, you may ask them. Please, can we have a pre-hearing conference? And please, can it be on the record? Because then you will have a verbatim transcript of the pre-hearing conference and you will know everything that the hearing officer expects, the timelines of everything, and it gives you sort of a roadmap for going forward. So that's very important for if you're representing yourself. Sometimes there's a pendency hearing before the actual hearing, as Tara and I believe Julie mentioned. And that hearing for pendency is only necessary if the parties are disagreeing about what actually is the pendency. In other words, what are the services that I'm trying to freeze for my child that I've agreed to in the past? That's pendency. And if the district and parent don't agree, there has to be a hearing on that, and that you take evidence to the hearing. And then the IHO makes an interim decision on pendency to establish what the pendency is that will then last throughout the hearing and through the next level of appeal. The procedure for the regular hearing is disclosure of evidence is extremely important. These are complicated things. The evidence has to be disclosed to the other party within 5 business days before the hearing starts. Documents have to be marked. Parties have to include their witness lists with their disclosure, so they have to really know who they are calling as witnesses and what that person is going to be talking about. And most hearing officers do want to have that information from the parties before the hearing goes forth. The rules of evidence are loosely applied because it's an administrative procedure, so it is less formal than a court, which is the good thing. In these hearings in the state of New York, the burden of proof is on the district to prove that it did. Most of these are cases that allege a failure to for the district to provide a free, appropriate public education for the child. So, but the district must prove that they did indeed provide that. Okay. And the standard of review for the hearing officer is, has the district school provided the student a free, appropriate public education? And, you know, that really does come into play in most of the hearings, except maybe if it's only for an evaluation or something like that. But that's very standard. Can we have the next slide? So what to expect at the hearing. Now, the location of the hearing is in person or online. I will say 99% of the hearings that I've been involved with since COVID have been online, and people really discovered that it's much more convenient. But it is true that if the parent wants the meeting to be other than online, the hearings by regulation in New York State must be at the convenience of the parent. So you can expect the hearing to be virtual unless the parent would like to have it otherwise. Each side will present witnesses and submit documents to support their case, of course. The evidence all becomes part of the official record of the case, and transcripts will be created of every hearing date. There may be more than one, there may be more than two. Upstate, there are typically more days of hearing than you would get in New York. So you're most likely going to have at least 2 days of hearing. So you will be getting transcripts of everything that happens verbatim. The witnesses usually testify in person, and by that I mean virtually. They are sworn, and they can testify via affidavit, but that would be by agreement. The parties would let the hearing officer know that ahead of time. But most of the upstate, most of the hearings are the witnesses appear in the hearing virtually. Mostly, not always, but mostly after the hearing's all concluded, the transcripts are received, the parties want to write briefs telling the hearing officer why what they want is appropriate and why what the other side wants isn't appropriate. Both sides want to tell their story. And the hearing officer will have different timelines set for that, but just, meet any timelines that the hearing officer gives you for filing briefs. I think next slide, please.
Hey, Jean,
Yes.
I'm just watching the clock, so I think we're gonna maybe have to rely on the slide mostly for this. If you can just do this one pretty quickly.
Sure. So I'm just looking at this to say, I think we can rely on the slide. It's just basically once you get your decision from your IHO, and if you want to appeal, you must meet the timelines for appealing. You have to, that's the middle of the page there. So keep that in mind. It's very important. It just happens that the Office of State Review is backed up with a lot of their appeals right now. And I don't know how they're handling it upstate, but they're very backed up. And so they are dismissing a lot of items for being 1 day late, or just, you really have to get in according to these timelines and those bullets in the middle of this slide. So, and then there's the hyperlink to the parent guide to appealing a decision of an impartial hearing officer. So take a look at that as well. And I believe that's
all right. So
it for them.
Jean, I'm just going to say this quickly. The next two slides, one talks about expedited hearings, and that's just a quicker timeline. It's like a 30-day timeline. It's really only available. You can go to the next slide, Laura. It's really only available in disciplinary related actions. So if a child's being suspended or threatened with suspension or longer term suspensions, there's protections that come into play for students with disabilities. And when those decisions are made, there's an opportunity to do a hearing in a much quicker fashion. We will be sharing this presentation with folks. I'm not promising it's going to be today because of a staff issue that I have here. But if not, it'll be within the next week. And I encourage you to have a look at this slide because we really put the information you needed on this slide. And then the second scenario is tuition reimbursement cases. And I bring that up just because there are so many of them, especially in New York City, way more in New York City than there is upstate. But those are cases where a parent feels that the placement and IEP that this district is recommending does not meet their child's needs, and therefore they want to place them at another school, and they want the school district to pay for that child to go to another school. Things are a little bit different in those under that scenario. The first thing is the parents have to give notice at least 10 days in advance that they are in fact going to place their child at another school and they're going to seek tuition reimbursement, or they are going to privately pay for services a student needs and seek reimbursement for those services. In those cases, the burden of proof is going to be on the parent, and there's going to have to be a demonstration that whatever IP the district was proposing did not meet the special education needs of the student. Two, that the program that they are selecting, where they've placed their child, can meet those needs of the student. And third, that everybody's played fair ball, meaning there was notice to the district in advance. The parents didn't, prevent the district from conducting evaluations and so forth, and that the district also maintained its obligation. So those are, a very common type of due process hearing. Again, a little bit more tricky because the burden is on the parents. So just something to keep in mind. So I think we can move to the next slide, which I'm very, very quickly just going to talk about the need for an attorney. I think we've already discussed that. I think all of us have mentioned Jean feels there's certain circumstances where you wouldn't need an attorney. And I think that's true as long as you are someone who is organized, is going to read the guidance, know what your timelines are, be communicating with the school district's attorney, because they will have their attorney involved, and communicating with the hearing officer. If you can keep yourself organized and it's a straightforward issue, parents may very well be able to do that. If that's not what you're able to do for a variety of reasons, then I have to say I would strongly encourage you to have an attorney. And fortunately, the IDEA does allow for reimbursement of attorneys' fees under certain conditions. So you can go to the next slide, Laura. So for example, if I go to a due process hearing on that placement issue and the hearing officer says, yeah, that child doesn't need a more restrictive setting, I'm ruling in your favor and your child can stay in a less restrictive setting. If that's the case, I am the prevailing party. I have won, and I can then turn to the school district and say, you need to reimburse me for my attorney's fees. I can't get my costs back, but I can get my attorney's fees back. Just caveats on that, you can't recover for the time your lawyer may have spent at a resolution session or in CSE meetings. But for working on a complaint and representing you at hearing, all that, you may be able to get those fees reimbursed, which can be very helpful. However, there's caveats to that too. If the district had made an offer to you that gave you what you wanted or close to what you wanted, and then the hearing officer gave you less, you might not be able to recover those fees. So it's a little bit complicated, maybe also worth talking to an attorney about whether an attorney, involving the attorney, may make sense and the chance of success in terms of recovering those fees. Okay, so I think we should try to get to questions now. So I have a whole list of them. I have been trying to answer some of them a little bit, and I think Tara has two, but I can't figure out everything that everybody's done. So I'm just going to start from the beginning, and I promise we'll get through as many of these as we can. So one question is, first one, what are some organizations who can help parents in the mediation process or in these kinds of things? The Parent to Parent of New York State is very good. So is Starbridge. Both are federally funded parent technical assistance centers, but they're PTIC. Anyway, they're technical assistance centers. Just Google Parent to Parent or PTIC, and you should be able to come up with one in your region. I see someone is on here from Starbridge. If you want to put a link in the chat or send it to us, we can put it in the chat. Disability Rights New York and some legal aid organizations also provide some legal assistance in special education matters. All of them, including DRNY, has an intake process, so you kind of have to go through that process. And I think that's all. Does anybody want to add any other resources?
The only other addition I would have is some of the law schools may have a legal clinic. That may be another resource. It depends on the area, though. That's not everywhere, but that may be another option to contact your local law school if there happens to be one to find out, do they have an education law clinic? And if so, that may be another resource.
Great. I don't know the answer to this. So can foster parents file a due process complaint even if the parental rights of the child in their care has not been terminated yet?
So it's going to depend on the circumstances. Technically, a foster parent will be seen as the same as a parent under the provisions of the definition of parent under the IDEA. If a biological parent's rights have not been terminated but have been subsumed by a current order that gives a foster parent sort of the decision-making authority, they may be able to initiate the hearing. So it's really going to be a more fact-dependent case. I would say they can go ahead and initiate the hearing, and if there's an issue, the district may raise that, and then we will ask the hearing officer to weigh in. But generally speaking, a foster parent does have similar rights to a parent when the child is a ward of the state and in the care and custody. Even though the bio parents' rights may not have been terminated, if the bio parents do not currently have custody, then the foster care parent can step in and act on their behalf.
Thanks, Tara. Related to that is a question that was posted just a little bit ago, which is, can a special education teacher initiate one of these three processes? And the answer to that is, first of all, kudos to you, special education teacher, thinking about advocating for your kids. That's great. But no, I don't think you can initiate a due process hearing. I do know for state complaints, certainly kind of anybody can file a state complaint on behalf of a student. So organizations can do it and parents can do it, but other entities could too. I wrote this in a few of the responses. Sometimes before you file a state complaint, it's worth reaching out to State Ed Quality Assurance, CEQA. CEQA is actually the unit that investigates state complaints, but there's regional associates assigned to different parts of the state. And sometimes a call to them explaining what's going on, they can work behind the scenes because frankly, they don't want to have to investigate a state complaint. So they're kind of motivated to try to step in and help ahead of time. So if you just Google State Ed, New York State Education Department, Special Education Quality Assurance, SEQA, you will find all the information you need to contact a regional associate. I don't think you would be able to do mediation on behalf of if you weren't the parent.
No, okay. I mean, you have to have a legal standing in order to pursue mediation or the due process, but the state complaint process is one that they could pursue.
Okay. Jean, when you go to due process for tuition reimbursement and are successful, does that mean you have to keep going back every year for tuition reimbursement?
Yes, I mean, in one word, yes. I mean, you may not be in that school forever, so every year that you feel the district failed to provide a FAPE and thus you were removing your child to this special education, a different placement, yes, you have to file. That's the only way to do it. And filing also holds the pendency to wherever it was. So it is an annual process.
Thanks, Jean.
Yeah.
I want to correct this. Could you clarify whether if mediation is unsuccessful and the case proceeds to an impartial hearing, we will be permitted to present the information and evidence discussed during the mediation? No, you will not. Mediation, what happens in mediation stays in mediation. So think about it like Vegas, right? It's like Vegas. So you really are not able to say, well, in there they admitted that they did this or what, or you were willing to do that. No, what happens there stays there, and you will not be able to use that in an impartial hearing. Let's see. Can CEQA help parents file state complaints? No, but they do have great guidance on the website. So we gave you that link. I would, if you're interested in a state complaint, go look at that link. It tells you how to do it. Can you appeal the decision if the state rejects the complaint? I don't think so.
No, not on the rejection of the complaint, but if they issue, I just answered that question. If they issue the complaint and they reject it, they're going to identify in their letter what's the reason for the rejection of the complaint. And if it's something that you can correct, you then could resubmit the complaint with whatever remedy was not addressed. So for example, if it is not an original signature, they will reject the complaint. So if you faxed it to them instead of mailed it to them, you need to make that correction. And then they may, accept it upon the second part. If it's outside the scope or it relates to an issue that is not subject to the state's review, they may, also advise you that there are other resources that you can refer to, and it may refer to federal, issues could be brought before the Office for Civil Rights. Or it may, again, if it's a matter of you're outside the timeline, but you still feel that there's an issue that could fall within the timeline, you could refile, raising the appropriate timeline within the 1 calendar year. Thanks. The only appeal you have from a state ed complaint is after the issue is decided. If you disagree with the outcome, but it is based on a factual inaccuracy, you can submit a written response, either party, within, I think it's 15 days, and then they will either make technical corrections or reject those technical corrections. That's the only option you got.
Thank you. Jean, what sort of timeline could or should a family expect for a due process hearing?
Wow. And it depends, because if you do have 2 lawyers, it's going to be longer. Because they will ask for extensions, for witness availability, or, legitimate reasons for extensions only need apply. But I mean, from filing, typically the parties are really not ready to move forward within the first 45 days, and the hearing hasn't happened. So wow, it could be, you could maybe with a non-expedited hearing, the fastest one, it's not going to be much faster than 6 months.
My is 2 to 5 months, and it depends on the issues, and it depends on expedited or non-expedited. But yeah, you have 30 days of resolution, 14 days from the end of resolution to schedule the pre-hearing conference. So you're already at almost 45 days. Technically, there's 45 days in which to complete it. So minimally, you're probably going to be within like a 3-month window. But because most parties will take more than 1 day, or may need more than 1 day to present the evidence and then submit briefs, I would usually tack on another 2 to 3 months. And that's assuming everybody's working expeditiously. There is a big difference between how long it takes upstate versus downstate. And when I say downstate, it's, anything like sort of south of Westchester constitutes getting into the city. Upstate, I think that we typically will do full days of hearing. Downstate, they may, take testimony for an hour. It's very different in terms of how those matters proceed. So that will also impact the duration of a potential hearing.
Yeah, I think that's true. Also, again, if the parties ask for extensions that are legitimate, it can extend it for, you might lose a witness. A witness might be in the hospital and they really need that witness. Can we get an extension to wait for this witness? Yes. The hearing officer can say no, but there are many reasons why delays come into it. Yeah. Sometimes you're waiting for a long time for the transcripts to come back, and the parties want the benefit of the transcripts when they write their briefs. So there's other things, but yeah, I would say I would never expect it to be done within faster than 6 months from start to finish.
I agree that that's probably accurate, but just remember that there's the pendency thing at play there too. So
Oh, yeah.
it's going to
Yeah, and
say
that
that.
can be handled even if the
Right.
rest of the hearing is delayed for whatever other reasons. The pendency can be can be handled if there's a disagreement and there needs to be an order. That can be handled very early, can be handled before the end of the resolution period. So
on expedited matters revolving discipline appeals, that's where I was talking about 2 months, because I've resolved those from beginning
right.
to
Got
2
it.
months, but that's also an abbreviated timeline.
Yeah,
15 days
excellent.
complete resolution, and then you must initiate within a certain number of days thereafter, and it's a much tighter timeline. That's why I said 2 months.
Definitely.
All right, colleagues, we got lots more questions. This is a really quick one, but it just said, is it common for a school district to retaliate against a child or a family if the parents file a due process? That is absolutely illegal. It's completely illegal if that's happening. And if you believe that that's happening, I would either raise it with the hearing officer or file a complaint with state ed that something like that is happening. What if the district says the attorney is attending mediation and you are not bringing an attorney?
It's not precluded, but it is strongly discouraged both in the US DOE commentary to the federal regs as well as state education guidance. However, I would say it should be the exception, not the rule. I will say in some instances, the advocates may be working for an attorney's office, and that may be instances where the district will feel, because there is such a clear alignment, that they may say, we want our attorney to attend. But that's really the only experience. Most of the time, if the parent is represented by a non-attorney or is not represented at all, in my districts, we do not typically have attorneys attend. I can't say that that's universal. Others might perceive it differently, but for me, I only attend if an attorney shows up.
Okay. And this is a pendency question. If you are the scenario I gave, a more restrictive placement is proposed, parent disagrees, parent files for due process hearing and invokes pendency. What if that same program isn't available? Like the kids going from grade school to middle school or middle school to high school. So they would have to be held back to be in the same classroom. So they're required to provide something that's of the equivalent to. So it couldn't be more restrictive. It has to be similar to. So if there was a co-taught in the next grade level, then that's what it would be. And if there isn't, then I'm thinking, Tara, they're going to have to get creative in making.
They may have to do comparable. I mean, what we usually see this happen a lot in the preschool CPSE to CSE transition, where if there's a disagreement as to the initial IEP for a school age, and maybe the student was in an integrated preschool, and if the school was proposing a self-contained program, that may be where there's a dispute. We don't keep the child in preschool. They move into the school age program, but the pendency would be what would be the school age equivalency of the preschool program, and that's how that would be designed. And as for other examples, if the district doesn't have an in-district option, that's where we get to the point where the hearing officer may have to weigh in and say, you need to create a program. If, for example, the district was recommending an out-of-district program and the previous district program had been in-district self-contained, that may be where you have there's no movement. And so we have to figure out how do we provide something comparable. And that's sort of the only example I can think of where you might end up having to create it. More often than not, it may be that the student will maintain a similar program in district, assuming it exists.
Right. I agree.
Sometimes it's the opposite.
Yeah, I agree with that. And one thing to keep in mind is the pendency is, as much as we want it to be sometimes, it's not actually in the brick and mortar place where the kid is. It's, as Tara, suggested, it's the services. So the services need to be replicated as closely as possible, but it may not be in the same place. So.
All right, it is past 1:30. So first, I really want to say thank you to Tara and Jean, because this has, one, been fun, and two, you guys are so knowledgeable, and I know everybody appreciates your perspective and what you had to share here today. So I know you're both busy, and I appreciate your time in doing this. I know we didn't get to every question, but I think we got to the ones that weren't like super specific about a specific situation. But we will be sharing this information on, like I said, it'll either probably go out today or it'll go out next week. I'm just not sure which, and we'll let you all know when the link is available for the recording. And I will also say, please, please do fill out the evaluation when you get it, because we want to know, we want feedback, but we also want to know, what do you want to hear about next year when we do this Lunch and Learn series? So thank you very much. And I think that'll conclude our session today.
Thank you.
Right. Thank you all.